As I am, yes, sir. I'm aware.
He knows how to delete and clear his cache, right?
Are you saying that based on because his exposure as a web developer? I would assume so.
And based on your experience here, in this case, you pointed out where this wasn't automatically being cleared every 90 days. This was manually done, right?
Yes.
Right. So there's evidence that he knows how to do it, correct?
Yes.
Right. He didn't clear all of his search history on the other browser, right?
On the Firefox, correct.
Right. He didn't clear all of the evidence of filth that he was still putting on his phone on June the 18th, 2014.
Correct.
Right? And in fact, now that you know that he's a web developer, you're now backing off a little bit about the testimony you gave this morning regarding the Griffin Psychology website, correct?
Judge, I object to the phrasing of the question, backing off. You know,
His testimony has changed. I got him across.
That's him across.
My understanding of that particular website was on face value. I saw the website. I did some research because I was unfamiliar with that website.
Who told you to do that research?
Nobody. I did it on my own when it came back in the preferences.
You did that on your own. When we came back from lunch, your testimony was that you only used that Griffin Psychology website as an example of what you found in his preferences, correct?
Again, my morning testimony was I went and I investigated. I looked at the website just in the off chance that you or Mr. Evans would have asked me a question about it. So this afternoon, I later learned that he had done some sort of work involvement with that with that company.
Okay. Who brought that to your attention?
Mr. Evans did.
And Mr. Evans has been your point person in this case, correct?
Yes, sir.
He's the one that assigns you tasks in this case, correct?
For the most part, yes, sir.
Okay. And this morning, you swore to tell the whole truth about finding this website and the preferences and suggesting to this jury that he was learning about juries and forensic evaluations, correct?
I don't think anyone made that suggestion.
That's exactly what he testified to.
No, it's not. What he testified to is using the example of what was on the left side of the page versus the right side of the page. There wasn't any testimony about what evidentiary significance might be attached to that, but an example.
He has him on cross. He has wide latitude. Jury will have to determine from the evidence.
When you read that website out, you told the jury, listen, I looked at this website. I did some investigation. I want you to know that when you go to this website, okay, you can learn about juries and forensic evaluations, and you thought that was suspicious, right?
As at about 9:45 this morning, yes, sir, because that's when I looked at it.
You've been assigned two main issues to look into over 2 years. Yet, on your own, you're willing to testify to the jury about something that you just threw together in the last couple of days?
I wouldn't say it was thrown together. One, it was 30 months from the date of engagement to today. And second to that, the list kind of grew over time. The report you're referring to was done March 2016.
goes through and it's all Google certified response and the certification's already in.
I think I want to go through the witness, I want to look at all the exhibits, please.
It's already in.
It's already in, why we have to put stickers on them.
The business record's already in. Anything that came from Google, attached to that business record certification is in evidence. There's a disc from one exhibit.
All right, well, I'd like the board to do the witness. All right, so I've been presented with some documents from Google. Did you get any documents from the company Google that you were asked to review as part of your responsibilities of the case?
No.
Okay. Have you looked at any Google chats or Google information that was provided by Google as part of your responsibilities as the forensic investigator that was asked to assist with the state?
I did not.
You have no familiarity or know nothing about these chats that apparently come from State's Exhibit 601 from Google?
I do not.
How about screen names or anything like that? Do you know anything about that?
I do not.
Judge, I'm going to object to those exhibits, I think for obvious reasons.
Well, there's nothing before the court.
Well, I'm going to move 88, 89, and 90, Judge. They were in response to a Google, or a search warrant to Google, and the response and the disk is already in evidence, along with the certificate of authenticity. That's Exhibit 601. This very content was inquired about after the break on direct examination.
What is your foundation?
Well, the foundation's already been laid because the certificate of authenticity is in.
What is your argument, Mr. Evans?
He's got no personal knowledge to authenticate these separate exhibits, whether they're pulled off of that disk or not. He's already testified he has absolutely no familiarity with it. So while those might be original business records that are sitting over there with the state's exhibit sticker, these records he's holding in his hands with the defense exhibit stickers, there's no authentication for it if this witness knows nothing about them.
Judge, the foundation has already been laid with the certificate of authenticity. I've got him on cross, and I should be able to ask him very specific information about items that are already in evidence. They're just singled out.
I sustain the objection.
You weren't made aware that Ross Harris was a web developer that worked for Griffin Psychology, Michael Griffin, PhD, were you?
No, sir.
Okay. Were you aware that Ross Harris and his friends at Home Depot had created a new web development company?
No, sir.
Okay. Were you aware that Griffin Psychology was a new client of Ninth Hour Development?
No, sir.
Okay. Did you know that Ross Harris had been serving as the web developer for Michael P. Griffin, PhD, all the way back to February of 2013?
I did not know that. No, sir.
Over the break, were you shown any of that?
No, sir.
Did you tell Mr. Evans that you were going to testify that griffinpsychology.com was something that Ross Harris deleted from his preferences because it has something to do with juries and psychological evaluations?
No, sir.
You just decided to do that on your own?
I used it as a reference in the preferences page, and thinking that you might ask me questions about that website, I looked at it at about 9:45 this morning.
But you didn't bother to ask about the context of any of that information?
No, sir. The best I recall, Mr. Evans was in court while I was on standby. There was no way to ask him about it.
You made a point to discuss this website, privateinternetaccess.com, correct?
Yes, sir.
Can you have that up there? States 922.
Yes, sir.
Right. And you found that this website was visited on Ross Harris's computer, right?
Yes, sir.
Now that you know that he's a web developer, that he had a new business, private clients, you'd agree that this sort of service doesn't mean that he's planning some sort of crime.
I would think if he's a web developer, he'd create his own. He wouldn't use another third party. That's what I do.
Have you gone to this website?
Yes.
Okay. So you're aware that it is sponsored by Forbes, MSN?
I'm not aware of that. I'm just aware that it's a VPN, a virtual private network.
And a lot of companies might use it, correct?
Yes.
Right? And in fact, Ross Harris, he didn't purchase it, right?
I'm unaware if he did or not.
So you're willing to testify that this piece of evidence was found on his computer, yet you didn't do the follow-up to see if he even purchased the service?
No, sir. Again, that was discovered about 3 days ago.
Yet you were willing to testify about it?
I'm willing to testify. I know he went to that website. Yes, sir.
You didn't know that he didn't purchase it?
No, sir.
There's a photograph of a dad and 2 children on a bicycle, correct?
Yes, sir.
This isn't necessarily marketed towards people that are planning to tamper evidence.
I think that would call for speculation.
This day.
What else did you do over the last few days that you didn't include in your report?
Well, again, that report was done in March of 2016.
You didn't update it.
No, sir.
In the last few days, you could have done that, right?
I could have done that. Yes, sir.
Were you directed not to?
No, sir.
When you found this a few days ago, when did you turn it over to the state?
About 48 hours ago.
Okay. Did you plan for it not to be disclosed until this morning?
No, sir. I sent it to him about 2 days ago, so
You didn't have any control over that.
I did not. In fact, some of it, I believe, came as late yesterday,
What was that?
the preferences.
The preferences. You mean the Griffin psychology? That slide?
More particularly, the slide about the browser history being deleted, those 4 screens, not just the Griffin. There's not even a printout for Griffin.
You testified that in looking at the Firefox search history, you found that there was searches for patent, correct?
A few of them, yes, sir.
And because it's more than one, you would agree that that appears to be something that he is assigning a little more attention to, that topic.
I think you're confusing the topics. The Reddit that I talked about earlier and the percentage of 80 because there's ones, we're talking about his whole Firefox internet history. I don't know what those compare to. It's pretty voluminous, the Firefox history. It would take boxes to print out all of those.
And he didn't delete any of that.
None that I could tell. Again, I saw a lot of it. I was able to search it, and with what I searched it with, didn't find what I was looking for, so I went back focusing on Chrome.
What were you looking for?
Again, I wrestled with the topics of hot car, child in a hot car, taken by heat, the list goes on.
Okay. Murder?
I'm sorry?
What about murder? Did you look for that?
No, I did not.
Okay. What about homicide? Did you look for that?
I did not.
What about malicious intent? Did you look for that?
I did.
What'd you find?
I did not find that, but I did find references to OCGA, Official Code of Georgia.
Okay. And what statute was that?
Yeah, it didn't have a statute. It actually just listed that Official Code of Georgia. Sometimes web links don't always put the whole link on the data, so you only get fragments of it.
So what did you make of a Georgia citizen that was looking at Georgia law? What was the conclusion that you drew?
I guess some interest or some question about law.
Could it have been forming an LLC?
I would have went to the Secretary of State's office for that.
And you did that, didn't you?
I can't say that I didn't see that.
You didn't see it?
Again, I didn't know of his private business.
Fair to say that when you look at all of someone's electronic devices, you can learn quite a bit about their private business.
Yes, sir.
Okay. So you learned about his private business, correct?
To a degree, yes.
You had boxes and boxes and boxes of Firefox web history that you could have gone through that he did not delete, correct?
Yes.
You could learn quite a bit about someone based on what they do on the internet.
Someone or the spam that they receive or the pop-ups they receive, the junk that they may get through their browser, all the other miscellaneous garbage that can come from the internet.
What else did you search for?
I believe that's it. I mean, it was very limited.
Okay, so hot car, child, murder, homicide, or no, you didn't search for murder, you didn't search for homicide, but you did search for malicious intent.
This is the phone here. Yeah, that's the data on Facebook. This, yeah, next to a screenshot there. With the wrong PC. Oh, it is. Yeah, oh, it's got it.
And what's been pre-marked for identification purposes is D91. You talked a little bit on direct about searching for age of consent. Is that the image that was found on his phone?
I believe so, yes.
I'm going to move D91.
Okay.
Admitted.
This is a screenshot of the age of consent in Georgia is 16, and there is no close in age exception, correct? That's the first couple of lines.
You're saying this page 1 is a screenshot.
Yes.
It doesn't look like the screenshot that I was able to see.
I'm sorry, and maybe I'm using the wrong technical term. What is this?
Well, it looks like it's been a retyped of what that message would have been.
Who retyped it?
I don't know. I need to look at it closer on. And I need the actual picture blown up, but it doesn't look like the complete content of the thumbnail picture.
Mr. Rodriguez, is that an iPhone 5?
It is.
Just speak things along the Uconnect readers up.
If you want to go through that with me, do you have any reason to believe why this is not from the iPhone 5S?
I don't.
Okay. All right, and you would agree with me that this first page of D91 says the age of consent in Georgia is 16, and there is no close-in age exception, correct?
Yes.
And then, though the offenses are a misdemeanor rather than a felony, in cases where the perpetrator is less than 19 years of age and is no more than 4 years older than the victim, correct?
Yes.
The crime of statutory rape makes it illegal for a perpetrator of any age to have sexual intercourse with someone under the age of 16 that they are not married to, correct?
Yes, sir.
Then it says, this law specifies that a defendant cannot be convicted on the testimony of the victim alone, correct?
Yes, sir.
Some other evidence must be present. This offense carries a minimum sentence of 1 year in prison and a maximum of 20 years, correct?
Yes, sir.
If the offender is 21 years of age or older, the minimum is raised to 10 years in prison, and the offender is subject to sex offender.
Okay.
Okay? And I've read all of the content that's on this first page of D91, correct?
Yes, sir.
All right. You would agree that this appears that Mr. Ross Harris researched a statute in Georgia, correct?
On the iPhone, yes, sir.
Okay. So certainly that would be evidence that if he wants to research a statute in Georgia, he can, right?
Sure, yes.
He knows how to.
I can't testify if he does or doesn't. I can assume he does.
Okay. And you would agree, he never Googled, searched for cruelty to a child.
I didn't search for those terms.
Did you find any evidence that he searched for cruelty to a child?
No, sir.
Did you find any evidence that he Googled or searched for homicide?
Judge, I have to object to the phrasing of the question. There's already been testimony, there's only search history for this 17th and the 18th. This makes it sound like there's no evidence of search at any time, so I think it needs to be qualified for what was available to be looked at.
I'm talking about all the electronic devices.
Go ahead.
In all the electronic devices, you didn't find any evidence that he searched for homicide.
No, sir.
You didn't find any evidence in any of his electronic devices that he searched for murder.
No, sir.
Okay? You didn't find any evidence that he searched for malicious intent.
No, sir.
Okay?
But just like in similar cases where I may be investigating a drug dealer, I might search for money and I might search for drugs, but just because you have money doesn't mean you sell drugs. So sometimes you search for things unless you know his words, his vocabulary. You can't say that something doesn't exist.
Well,
Maybe he misspelled it.
fortunately, we know a little bit about his vocabulary based on his interview with police, correct?
I never watched that interview, sir, so I wouldn't know his vocabulary. I was faced with looking at data. Data doesn't talk to me.
Did you know that he used the phrase malicious intent?
I had learned that through the news.
Through the news?
Yes, sir.
Did you discuss that fact or allegation with the district attorney's office?
No, I did not.
They didn't ask you
No, sir.
to search for malicious intent. Or no, you did, right? You did
I
search.
did search for that.
Okay. Did they ask you to do that?
No, sir.
You did that on your own.
I did it on my own.
Did you tell them, hey, there's nothing?
I did not.
You didn't tell them that you didn't search for malicious intent?
No, sir.
Is this the first time that you're actually letting the district attorney's office know he never searched for malicious intent?
I spelled it correctly. I can't say that he spelled it correctly if he searched for it.
Is there any evidence that he misspelled malicious intent in a search?
Sir, I can't answer that question because I don't know how he could have misspelled it. He could have misspelled it a variety of ways, and that got him what he was looking for. I don't know. I just know the way I spelled it, it did not come back.
The Home Depot benefits summary that you looked at, Mr. Evans talked to you about on direct just after lunch regarding divorce. Mr. Harris never searched the word divorce, did he?
Yes, sir. I found the word. I put in the word divorce, and the document that had divorce in it came back. I traced it back and found the document where he searched up name change.
You have no idea why he would be searching for a name change. I mean, you talked about a lot of things you don't know. You don't know why he searched for name change.
Yes, sir.
But what you do know is that he did not search for divorce, correct?
Based on what I see, I got several returns on the word divorce, but the one that stood out, that to me was the most recent, was the one that associated with name change.
Again, he did not search, type in the word divorce. You did, correct?
I did in the forensic data.
And the word divorce just happened to appear on a document, correct?
A document that he clicked on yesterday.
You would agree that the documents that are available on this My Abrams account have to do with benefits, right? Maybe something that comes from human resources. I would be that.
I assume so.
Well, because you are curious at evidence of a divorce, did you bother to look to see if he had Googled a divorce lawyer?
No, sir.
You didn't bother to do that?
No, sir.
Okay. Did you come across any evidence that he had searched for a divorce attorney?
No, sir.
Did you come across any evidence that he had researched alimony?
No, sir.
Custody of a child?
No, sir.
And the boxes and boxes of web history that you had available across multiple devices, you never found anything related to a divorce other than this search for divorce that you did.
Search within his data, yes, sir.
It's just a document that's got the word divorce in it.
I'm sorry, I didn't hear you.
It's just a document that has the word divorce in it.
He puts in the word name change, and he gets back a return, a link, that talks about a checklist for divorce. He clicked that link. There must be some interest in that.
Doesn't mean that he wants to have a divorce.
Again, there's some interest in that.
You don't know that.
So I don't know that there's not.
Because you need to do more follow-up investigations, right?
I could be more follow-up. I can say that you put in names change. You didn't click a document that deals with name changing only. You didn't back out of it because you put in something wrong. You clicked the link that is associated directly with a divorce checklist.
Okay. Maybe, just give you the benefit of the doubt, maybe he had some bit of interest in divorce. He had no interest, and you found no evidence of having an interest in murder, correct?
Using just that word, correct.
Any evidence that you went through, no evidence that he had any interest in murdering someone.
Again, I didn't search the data for those terms.
No interest in finding out what malicious intent was.
Correct.
Let me have you on the judge. talking about what he may be interested in, possibly. Is it possible that he was interested in purchasing a home?
We don't have anything support or not support that.
You didn't see any evidence on his electronic devices of all the searches for a home?
I don't recall seeing that, no, sir.
Did you see a Zillow account?
I don't recall seeing one, no, sir.
A Remax account?
No, sir.
What about emails? Do you have access to all the emails that came from Google?
If they were on his device, I would have had access. Did I search them? No.
Did you have access to the emails that were on his device?
If they were on his device, I would have, yes. I didn't search for those, so I don't know whether they were on there or not. Google doesn't store always, unless you tell it to, emails on your device.
Well, you went through the Whisper application on his phone. I'm showing you what's been pre-marked for identification purposes as D92. We agree that is a Whisper and the associated chat from the iPhone 5S, correct?
I'm sorry, could you ask that question again, please?
D92 is the meme and associated chat, the celebrite connected between those two items, the meme and the chat.
I would agree it appears to be that. It's got an incorrect timestamp on it. But outside of that, I would say it looks like it came from that, yes.
It says -5, correct?
And it should be -4.
It should be -4. Other than that, does this fairly and accurately depict the meme and the chat associated with this photograph?
It is, and again, it's the first time I've seen that document.
I'll move D92.
For what it's worth, no.
You'd agree that the meme is house hunting, so excited, right?
Yes, sir.
And since we talked about his activity and interests on June the 13th, you would agree that this chat was on June the 13th?
I would agree with that much, yes.
Okay. The user that created the meme is named, or the name of the user is Yada Ambient, correct?
Yes, sir.
And that's not Ross Harris,
Correct.
all right? Ross Harris is in green, correct?
Yes, sir.
He says, I just started as well, correct?
Yes.
And the other user says, it's amazing. Do you have a family? And Ross says, I do, correct?
Yes.
And then the other person says, my husband and I have one daughter, smiley face. I'm expecting. How many do you have? And Ross says, just one right now.
Yes, sir.
Do you know if Ross and Leanna had any interest in having more children?
Based on that, I would say yes.
Okay. Ross asks, where are y'all looking?
Yes, sir.
She says, in Atlanta, Georgia. Ross says, where in ATL? She says, Lithonia, correct?
Yes, sir.
Ross says, we're looking around Kesaw, and you take that to mean Kennesaw, correct?
I would agree with that.
/ Marietta, correct?
Yes.
She says, wow, that's cool. We're waiting to see if we'll get qualified by our bank. And that's the end of the conversation, correct?
It is. Now, if I may,
Sure.
if I was searching his data to see if he was looking for a house, and we take this picture by example, house hunting, 3 exclamation points, so exciting. Most of us would probably put the exclamation points on the end of the sentence, not in the middle of it, as it appears in this document. You see, when we're searching data, we have to be specific. We have to know enough that those exclamation points are going to be in the middle of the sentence, not at the end, or we get nothing back.
Ross didn't create that image.
No, sir, but you indicated he was searching for houses. If I wanted to agree with that or not, I would have had to known those exclamation points are out of place.
But if you're just looking at his activity on June the 13th, like we know that you can do, you would have seen that this communication was going on June the 13th, 2014, just 5 days before Cooper passed.
The communication in this document was not the focus of my part of the investigation.
Because the focus of your investigation was whatever they told you to do.
Not whatever they told me to do. They gave me, it's like running a 100-yard race. They got me to the 20-yard line. They gave me ideas of things that they wanted investigated further. I carried it the rest of the way.
And they didn't ask you to look into whether there was any interest or any evidence on his electronic devices of a future plan to purchase a family home.
No, sir.
Is it your understanding that they didn't want you to look at that?
We never talked about it. So to say they did or didn't, I can't answer.
Well, you would agree that as far as clearing your cache, that's not necessarily something that a web developer, that's something that a web developer may want to do, correct?
I would agree with that. So why didn't he clear both of them? It's the same computer, the same performance, but one browser gets cleared and the other does not, and they're on the same computer.
Well, is your cross to tape?
I'm close to it. Judge, if I can just, well, if we can take our break and I can set up my last point and use the Mondo.
I think that's fine. That's what I was interested in. I know the witness is going to have more time. Ladies and gentlemen, close your notepads, open minds, close lips, have a break.
Let's all rise up here, please. Please watch yourself going down. Please watch yourself going down.
Before the parties get off for their break, have y'all conferred with each other about scheduling? Seems like things may have changed.
Well, I think we anticipate we would close today. I really doubt that.
Oh, I do too. I was thinking about in the morning.
I think we'll probably rest my lunch.
Okay, good. Then that's on schedule, and if you're a little over that, that's okay too. I just think they should know.
Yes, ma'am. Everything else good? Good to be
I think so. Yeah, Loki's got it. You think?
Thank you.
Yes, I think so.
I'll get back to you. Thanks.
Right over past lunch, it sounds like.
Thank you.
Everybody get a break.